The SEC. So the SEC really was dormant for a number of years in this space. They kind of missed the boat in the early years. In 2011, the SEC came out with a staff guidance document that essentially said, don't forget about reporting obligations with respect to cyber incidents and cyber risks. You need to remember that this is something that you need to report on if you have material issues that need to be disclosed. But there was a quiet period after that, and I will tell you that just a couple of years after that was issued, I was representing a company before the SEC, and we were sitting at a conference, and the SEC made noises about bringing an enforcement action, and I said to them, well, this case is so different, fundamentally different from the 6 that have gone before, and they kind of gulped and said, could you send us those 6? So they didn't really have a sense of what their own enforcement landscape looked like. That picture has changed. The SEC is now very sophisticated and they're very active in this space. So if you do a survey of your peers' disclosures, you will see some very robust cybersecurity disclosures in their SEC filings. So what the SEC has done now is the 5 SEC commissioners came out in 2018 with a commission guidance document. So this is a very high-level guidance document. And if you're reading closely, what you really see is the Yahoo and Equifax rule. And I was just at the time sort of coming off of or continuing on with managing the Yahoo breach. And I read this and I thought, yep, this is speaking directly to the issues that have just come to the fore in the press. So what did the SEC say in their 2018 guidance? They said, don't give us boilerplate disclosures. We don't want to hear the following. We may face risks of fire, tsunami, earthquakes, cyber attacks, et cetera, et cetera. Cyber is not like any of those other issues, and you need to distinguish that it can't be boilerplate language. Now, we also don't want language that's going to give a roadmap to attackers, but you can't use boilerplate language. It needs to speak to your company's actual risk in this environment. And if you find out something a couple of years later that would have changed a disclosure 2 years earlier, for example, you need to revisit that disclosure and amend that earlier disclosure. The other issue that they made hay of is that to the extent your disclosure counsel and senior leaders are not deeply in the loop of cyber, you need to have controls in place so that they are told, they are informed about cyber issues so that they can make disclosure decisions. So this is the love your lawyer provision. So I encourage you to bring counsel in to these events to the extent they're looking like they might be pretty serious. I know you're pinged 64,000 times a day, but to the extent there is a serious event, certainly counsel should be brought in. And they are helpful, I promise, that mostly they're helpful. The other thing that the SEC said is, don't trade, right? We've been told for years and years and years about insider trading. And in Equifax's case, there were 2 insiders who did trade, and they also were criminally convicted for having done so. So the question is, do you put a blackout period in place, or do you hold off? Once you put a blackout period in place, people know there's something going a little bit awry, or a lot awry, so there's a little bit of a fine line there. But you know, blackout periods are really to protect people against themselves, because we know we're not supposed to trade when there's a material event, but people do it anyway. So there was a chunk of this commission report that talked about insider trading and selective disclosure issues. So the SEC formed a cyber unit in 2018. This is, so they really formalized all of this. And they have been bringing enforcement actions. So in April 2018, Yahoo settled their case for $35 million with the SEC. And by the way, also settled a shareholder securities action for $80 million. So these are big numbers. Equifax, as I mentioned, 2 people traded on their knowledge. That is a no-no, and they were convicted criminally. Facebook recently settled for $100 million with the SEC for misleading disclosures. The allegation there is that Facebook knew about Cambridge Analytica and the fact that they had violated their policies and procedures back in 2015, but did not disclose it in their securities filings until 2018. So that delay, as far as the SEC was concerned, was problematic. And also misleading, because what the SEC said is that Facebook indicated that there were hypothetical risks with respect to data misuse, but they knew about an actual concrete risk, and the SEC alleges that they should have disclosed it then. So what trends are we seeing generally? We are seeing laws that are newer laws that are more thoughtful and that are really embedding a risk-based approach to security. Think about your particular risk and protect against that risk, rather than imposing requirements that would be applicable to any company in the United States that really wouldn't be necessarily applicable to your company. So risk-based standards are very helpful, I think. I think this is exactly the way to go. But at the same time, we're seeing some more prescriptive rules around cybersecurity. So we see that, for example, in the new New York SHIELD Act that just became effective a couple of months ago in New York State. Also the New York Department of Financial Services cybersecurity regulations has very prescriptive rules that were then picked up by the insurance model law, again picked up then in certain states like South Carolina. Ohio has also a newish cybersecurity law that provides a safe harbor where if you implement XYZ standard, then you are safe from potential liability. So there are some good developments in this space, but as you can see, they still continue to be very patchy, really fragmented, and that's not a good way to manage cybersecurity. The other trend that I'll note that I think is very significant and will continue is the use of accountability mechanisms. So we are seeing in some laws, for example, the requirement to report to the board annually. In an Equifax settlement, there was a requirement to provide, management has to provide a report to the board on an annual basis. We saw that also in the Facebook settlement. So there are reporting obligations now to the board directly on cybersecurity issues. And the other key change is that we are seeing in the cyberspace requirements to report material issues to regulators. And what we're seeing, unfortunately, is a 72-hour reporting requirement. And I say unfortunately because that is really, really tough to meet. It started in Europe with the General Data Protection Regulation, the requirement to report within 72 hours. And now we've seen it picked up in other countries like the Philippines, but also in the United States. So we see the newer laws having a 72-hour notice requirement, which is that's not business days, by the way. That's 72 straight-on hours. So it's really tough to meet those requirements.